Testing Justice 7. Testing Justice 6. Testing Justice 5. Testing Justice 4. Testing Justice 3. Testing Justice 2. Testing Lavalier 2. Testing Lavalier 1. come forth and declare, and they shall be heard.
Good morning, you can be seated. The matter before the court is Penobscot 24-303, State of Maine versus John Schlosser. We are being streamed live on the web, both by audio and video. If counsel would introduce yourselves by saying your names for the record, together with the party you represent, starting with appellant.
Good morning. Tyler Smith for the appellant, John Schlosser.
Good morning. Jason Horn for the State of Maine.
Thank you. And Attorney Smith, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you. Good morning, and may it please the court. I've chosen to start with the green light on, so I'm happy to head in whatever direction the court thinks is most fruitful. The one issue that I had thought that stuck out
well, the green light's on, so
Sure.
let's focus on the lesser included offense jury instruction.
Was that the one you were going to go to?
that was the one.
Good call.
And I want to focus on the text of Section 13A. And I hope you have a copy. I want to focus on the last sentence of that. I can read it to you, but my question to you is, how do you interpret the meaning of that and in the context of this case?
Well, I don't have a copy.
I can
right
read it
here.
for you. It says, the first part is, the court shall not instruct the jury to consider a lesser included unless the evidence supports it on a rational basis. Then Section 2 is the definition as legally defined. Then Section 3 is about when it's not a lesser included, when you can instruct. And then the last sentence says, when the other offense is defined in such a manner that it may be committed in alternative ways, the court may instruct the jury to consider, or may as fact finder consider, any alternative which meets the requirements of this subsection. Are they talking only about Section 3? Are they talking in general about the issue? And how does the fact that the legal instructions seem to focus on the evidence that's provided, but the definition uses the words legally defined, and most courts, including the United States Supreme Court, say that you look at the statutory definition, not the evidence. How do we jive those together?
Absolutely. Well, I think that last section is referring to, like the statute says, when you have an offense and it can be committed in multiple different ways, the court can instruct on any of those. The issue here really turns on, what does the phrase legally defined mean? And in the context of a criminal trial, legally defined means the law that the judge gives to the jury. And it makes sense to interpret it that way when you look at why we have lesser included offense instructions in the first place.
Except that, isn't the whole idea of a lesser included, doesn't it derive from some of the case law related to double jeopardy, to merger? In other words, that we really need to look at the elements of the offense. And in this case, the state chose to not choose one of the subsections, shall we say, on the definition of traffic, right? They could have said in the indictment, traffic to wit, possession with intent.
That's right. And in this case, though, the judge did give the instruction that was trafficking is possession plus intent. And the fundamental question on whether to give a lesser included offense instruction is whether a guilty verdict on the greater offense necessarily means that the jury also found all of the elements of the lesser offense. And there's good reason for that.
And the question, the way we judge that, again, going back to double jeopardy, is by the nature of the looking at the indictment and the statute. The indictment may narrow the statute and choose only one of the alternatives.
Sure. And double jeopardy is one reason why you have that rule. But another reason that the Supreme Court has talked about is when a defendant commits acts that constitute only the lesser offense, the jury faces an all or nothing dilemma. They either need to convict the defendant of the greater offense improperly, even though that hasn't been proven, or they need to acquit the defendant outright. And that this choice, this catch-22 that the jury is placed in, the Supreme Court has acknowledged, distorts the fact-finding function of the jury and places considerable pressure on the jury to return a guilty
So there are
verdict.
really three different possible approaches to this. The first is using the statutory definition. The second would be as delimited by the charging instrument, like by the indictment, as to what the scope is. And then the third would be the actual evidence produced at trial as to which of the subsections applies. Are you, obviously you're not arguing for the statutory definition, but are you arguing first that an indictment can delimit the scope of lesser included? Absolutely just the evidence, the third alternative?
No, this court has held that the indictment can
I thought you were
limit this
mandating that.
in Goodall and Lucy. My point is that when the jury instructions limit the scope of the offense, that should be treated the same way as the indictment, because the fundamental question is, categorically, when the jury returns a guilty verdict for the greater offense, is it logically possible that the jury, following the jury instruction, could have done that in a way under which it did not find all of the elements?
So you're saying that the jury instructions are really the touchstone here, that that's the key to the scope of the lesser included, but not the evidence?
Exactly. I'm not arguing that the evidence itself would limit it.
Okay.
But the real question is, logically, is the jury enabled? Is there some way that the jury could find the defendant guilty of the greater offense without
So if these
necessarily
jury
finding-
instructions had simply recited as the definition of lesser included the statute, you'd say it's not a lesser included offense, even
the
though there's
full-
no evidence on how the other alternatives could have been committed?
I think in that case, if the jury had been instructed in the other ways of committing trafficking, then I wouldn't have that same argument.
Even if there's
because
no
there would be-
evidence? There was no evidence on those other alternatives?
Right, and I think maybe that would be a question for another day. It's one that I wouldn't need to reach in this situation.
Well, it would be a question for defense counsel. I mean, why would defense counsel allow that to go into the instruction?
Well, that was going to be exactly my next point, that in that case, defense counsel could object to including those other definitions. They could file a Rule 29 motion saying that the state hadn't met its burden as to those other alternative definitions. And I suspect that the reason why the trial court in this case limited the jury instruction to that one alternative is because there was no evidence of any of the other ones.
But just so I'm clear, you do agree that there isn't any authority for the positions you're advocating here at this point?
I agree. It's a matter of first impression on whether whether you consider the jury instructions.
And your dilemma in this case is that we also permit an instruction on possession would have been permitted had the state agreed to it.
It would have.
As they did on count 2.
Exactly, as in count 2. So the court could have given one had it chosen to.
Which is essentially a safety valve, though, as opposed to a requirement because it's a lesser included.
On the discretionary piece of it, yes, but my argument is that it was mandatory in this case because there was no possible way that the jury, following the jury instructions, could find Mr. Schlosser guilty of trafficking without also finding that he had committed the offense of unlawful possession of Schedule
It seems to me the
If the
statute
statute-
answers the question in a way, because it indicates that even if a statute or the indictment alleges or provides for alternative means of committing the offense, if there's no rational basis in the evidence for those other alternatives, the court is required to give an instruction that's supported by the evidence if requested by either party.
And I think that's right, and I think that supports this position that when a jury
Maybe
is
that's a
not...
question for Mr. Horn more than you, but it just seems to me that the statute is relatively clear in limiting lesser includeds to those that are supported by the evidence, but requiring the instruction to be given if requested.
And I think across all of that, you need to look at it through the lens of why do we have lesser included offenses to begin with. And it goes back to what I mentioned earlier with the Supreme Court and the dilemma that juries face when you have a defendant who committed one crime, but the question is whether they committed the greater offense, and you don't have an instruction on the lesser crime. So the jury on count 1, let's assume that it accepted Mr. Schlosser's
Well, you really
testimony.
shouldn't be citing the Supreme Court because they go the other way. Schmuck versus U.S., I think, says that you look at the statute. You don't look at the evidence that was produced in identifying what a lesser included was an odometer case. And the majority are against you of jurisdictions. There are, however, some jurisdictions that look at the evidence and focus on that. It's a minority, but I don't know why you keep citing the Supreme Court.
Well,
I'm
have
not
you found
suggesting-
any cases that support your position?
Pardon?
Have you found any cases that support
I have
your
not found
position?
any cases that address the issue of how it operates when the jury instructions limit the offense. I'm not arguing that the evidence limits the offense. I'm arguing that the law limits the offense, and when the law is the jury instructions that's given to the jury. The entire reason you have lesser included offense instructions is because of concerns about what is the jury going to do when they're confronted with this dilemma.
Well, that's not the entire reason.
Not the entire, or a significant reason.
It may be a reason from the defense point of view. It is not the entire reason for doing it.
No, fair point, Your Honor. But it is a significant reason as to why you have lesser included offenses is because of concerns about how the jury is going to deal with this all or nothing dilemma that occurs when you have a defendant.
And that
who
is a dilemma
committed-
for both the prosecution and the defense. I mean, we all know that in one case, the prosecution doesn't want the lesser included, and in the next case, the defense doesn't want the lesser included.
No, that's fair, and that determination can depend on what the evidence is and how strong the evidence is on one offense versus the other. But I do want to be clear back to the point that Justice Connors was making. I am not arguing that it's the evidence that controls whether you give a lesser included offense. It's the law that controls, and what I'm saying is the phrase legally defined is inclusive of the law that the jury instructions
Well, why
provide.
doesn't the evidence control?
Well, there's a good argument that perhaps it should.
Well, and the jury
But-
instructions have to be tethered to the evidence, right? So when you say it's the jury instructions are based on the evidence, so you really are in the camp of those, and there are some jurisdictions that focus on how did the evidence actually come out in determining whether to give an instruction on lesser included offense. There are no cases that I've found that just focus on the jury instruction, but implicit in your argument is it's got to be based on the evidence, isn't it?
It's part of it in the sense that how you get to the jury instructions is
All instructions have to be
the
based on the
evidence.
evidence, correct?
exactly.
How about a hypothetical where the evidence comes in and it would support any one of the alternative bases for conviction, but the judge only instructs on one particular subsection there? Where does that take us?
So I think where that takes us is the lesser included offense is appropriate if the judge instructs on only one, because categorically speaking, the jury had to find
Right, they
possession in
couldn't
order to
convict
find trafficking.
on the other theories.
Because if
Okay.
the jury's following the jury instructions, they had to find possession.
So your argument always circles back to the instructions.
Well, it circles back to what the law.
It seems to me that if the court had instructed the jury based upon the statute or the aggravated traffic indictment, we would have to vacate because it's possible the jury could have convicted based upon its view that a sale had occurred when there was no evidence that an actual sale had occurred.
I agree. If
Well-
if this court finds that.
Although, yeah, I see the time is up.
Thank you.
May it please the court.
Attorney
Madam
Horton.
Chief Justice, counsel. The initial detention was for a different reason than the search. The initial detention was not based on drugs. The initial detention was based on reasonable articulable suspicion of criminal trespass. Criminal trespass is simply not a close call in this case. And the defendant was in a partially walled private driveway leading to loading bays and dumpsters. It was clearly marked with no trespassing signs. And the owners had specifically asked the police and Officer Alvarado to look for people trespassing in that area. The video that's part of the record makes it unambiguous that this individual was in the location that was prescribed against trespassing, which leads to the next question of when did reasonable articulable suspicion of him being in possession of drugs arise. So there were certain factors that Officer Alvarado were already aware of at the point he decided to stop the defendant for criminal trespass. He knew first that businesses and residents in that area had complained repeatedly of drug activity in that specific driveway. Alvarado himself had personally dealt with many individuals for drug activity in that same driveway. Now, the business had in fact posted no trespassing or requested monitoring for drug trafficking in that area. And at the point that he sees the individual in the driveway and decides to stop him for criminal trespass, initially he reacted was to turn away and to attempt to avoid Alvarado's gaze and attempt to walk away. Again, by itself, standing in a vacuum, that's not RES, but again, RES is based on the totality of the circumstances taken as a whole. At that point, after he turned around, or during the point he was turning around, to Officer Alvarado, the defendant appeared to be rapidly concealing something in his pocket, both at the first sight of law enforcement coming behind him when he's walking away, and again when he's turning back towards the officer. The state provided in its brief specific timestamps to the exact 20-second period in the video when you can see this conduct happening. And it's worth taking into account the fact that Officer Alvarado did not have the benefit of a reviewing video because he was dealing with this in real time. Like, his perceptions in those 20 seconds were rationally justified and supported by what is in the record. At the point that he actually gets him to his car, he recognizes him then as someone that he's dealt with or found in the company of other drug users and at drug houses on multiple occasions.
Can you please address the lesser included offense argument?
Yes, Justice Connors. And I think I can answer your initial question to opposing counsel about 13A3, about whether that last sentence applies only to that section or the whole thing. I believe that it would necessarily have to apply to the whole section. However, if it was only applicable to Section 3, it would not matter because Section 3 is the one that specifically requires the consent of the state to give the lesser included charge.
Then why don't we base the jury instructions on the evidence that's presented? And why isn't the evidence that's presented defining what the lesser included offense may be?
And respectfully, I think that's a policy question because the 13A language is
Legally defined.
legally defined. It's very black letter.
What is the so you don't know what the policy could possibly be that the legislature would have said only look at the statute? And don't we have case law saying you at least look at the indictment?
Well, the case law says that the indictment can circumscribe the legal definition of the offense, and that much is clear. So if the indictment alleges a specific manner and means less than the broad definition of the statute.
Had it specifically alleged intent, I mean possession with intent in this case.
Correct.
Isn't the logical extension of your argument that the state gets to control whether a defense, whether a lesser included offense is available or not? All the state has to do is what it did in this case, which is draft a very unspecific indictment and then say, well, the statute legally defines 4 separate branches as a basis for trafficking, even though 3 of them are totally irrelevant. I mean, the statute legally defines the offense charged and proven in this case, doesn't it?
The statute, yes, the statute does.
Isn't that all we need to know? The statute, as legally defined, it's defined in one of the subsections under trafficking.
But this, as I believe the Chief Justice alluded to, implicates a bunch of other considerations that rely on the question of how an offense is legally defined. And it has been consistently, to the best of my knowledge, interpreted to mean what is the full statutory definition.
I know it's been consistently interpreted that way, but does that make sense? Especially, does it give the state the opportunity to control whether a lesser included offense is available for this particular charge?
I mean, to an extent, and it's a strategic consideration for the state, just as lesser included are a strategic consideration for the defense, as again acknowledged implicitly by the Chief Justice. It cuts both ways. So that interpretation prevents the state from getting a lesser included unless there's consent from the defense as well.
Well, I want to make sure I've given you every opportunity to identify what the policy would be for not focusing on what the evidence was and the legal instruction, the proper legal instruction in determining what a lesser included offense is. What could possibly be the policy reason for only looking at the statute?
I can't speculate as the policy reason for why the statute is defined the way it is, but it's clear the way it's written.
How is legally defined clear?
As legally defined.
You can be legally defined in a statute, you can be legally defined in an indictment, and you can be legally defined in a jury instruction. Can't you?
As has been pointed out repeatedly, neither party is aware of any support for the proposition that the jury instructions would control as a legal definition of the offense.
And in fact, to so hold would overrule all of our case law, multiple cases that we've had,
It would be very far-reaching.
as well as depart from others. Can I turn to the sentencing issue?
Yes.
How is cell phone very active during the stop possibly, first of all, an aggravating factor? And also, how is that different from saying there were a lot of drugs involved?
I'm glad you asked, Your Honor. So first off, how these two factors are distinguishable and why it matters.
I understand they're different words, but do they actually mean different things?
I believe that they do, Your Honor. And on the one hand, you have the sheer volume of the drugs, and then implicitly with the activity of the phone, you have the volume of customers for that drug, which is different. We could all agree that
How
having...
is the volume of customers versus the volume of drugs a different aggravating factor, though?
Because having 70 grams of drugs is worse than 1 gram, of course. And if it's only meant for one person, it would still be worse to have 70 grams than 1. However, on the flip side, if you had 70 grams...
So if I'm selling 70 grams to 2 people, that's better than selling it to 5 people?
I would say it's less aggravating. And here, the court is
Not sure I
able-
follow that.
Well, the court is able to draw rational inferences from the evidence as well. And here, that evidence is that you have a phone that's blowing up with apparently coded names nonstop while the defendant is in a high drug traffic area with not only approximately 70 grams of drugs, but it's all prepackaged into multiple small baggies for apparent redistribution.
In other words, there was actually evidence from which one could have found that he was engaging in sales with the packaging, the scale, the money that he had in his pocket, as opposed to simply from possession with intent.
I believe that is accurate as well, Your Honor. But again, and as it relates to the cell phone, it's a rational inference that I believe the sentencing court is entitled to draw from that in combination with the other facts that it is indicative, or certainly could rationally be indicative, that he had multiple different customers that he was intending to distribute this to, potentially myriad of different customers. And we do believe that that is aggravating to know how a wide customer base is a separate factor than how much you have, period. Like each of these, it's like looking at it as additional individual victims of crime. Like whether or not they're willing customers if they have substance use disorder and this defendant is feeding their addiction with poisons that are prepackaged for sale, then you're talking about him potentially giving that poison out to many different people, and there's evidence that could support that.
I'd like to take you back to the statute, section 13A, and subsection 2A of the statute says, if the lesser offense is defined in a manner that it may be committed in alternative ways, each alternative which meets the above definition shall be deemed to be a lesser included offense. That leads me to think that if the trafficking statute defines lesser included offenses in a number of ways, subsection 1 says that the court should instruct only on the alternative that has a rational basis in the evidence. Do you agree that there was a rational basis in the evidence for Mr. Schlosser to be convicted of possession of fentanyl powder as opposed to intentional or knowingly trafficking?
And I believe we conceded in the brief that there's a rational basis for that.
And that's why there could have been an instruction under subsection 3, which says that, that the 3A, on the basis of the evidence, there is a rational basis for finding the defendant guilty of the other offense.
Correct.
As one of the preconditions.
There's a rational basis that would support a consent instruction on that under section 3. But 2 also refers back to above, which encompasses the above section, which says, again, as legally defined. Like, one simply can't escape the language that it is an offense as it is legally defined, must be committed as it is legally defined.
Do you agree that it was within the discretion of the trial court to give a lesser included on possession?
No, I do not. Not under these circumstances. And if...
Because it wasn't a lesser included.
Correct.
Okay.
It's not a lesser included, therefore it was not within their discretion. There was simply no error under the law as it stands.
And doesn't 2A, when it talks about if the lesser offense is defined in a manner that it may be committed in alternate ways, it seems to me, and that each alternative which meets the above definition shall be deemed to be a lesser included offense. That's dealing with, for example, the situation that we had in State versus Ellis, where it was a murder and then the jury was instructed on provocation, which wasn't generated by the evidence, but what was generated by the evidence was negligent manslaughter.
Right.
And so there's more than one way it could be reduced to manslaughter, and the one that should be instructed on, if it's a lesser included, is the one that meets the evidence.
Right.
Can I just take you back very quickly to what you were saying about the double counting? So you're saying that the distinction, or at least the process that the sentencing court went through, was to have one factor that it considered in the first step, which was the context of the amount of drugs, the volume of drugs that were involved.
Yes.
And then what the court was looking at in the second step was just simply the scope, or if you will, the size of the population that, or the number of people that appeared that this particular individual was involved in terms of trafficking in the drugs.
Yes, I agree, Your Honor. A trafficker could be servicing 1 to 3 people, 1 to 5 people, or they could be servicing dozens of people.
So the customer base.
Yes, exactly. Any other questions?
There don't appear to be. Thank you. And Mr. Smith, I think you reserved 2 minutes for rebuttal.
Yes, thank you. I would just simply ask, what logical reason exists for letting the state limit the scope of the greater offense in the indictment for lesser included offense instructions?
Isn't that a
but
question
not
for the legislature, though, at this point? In other words, we have said repeatedly how to determine this.
Yep.
This statute has been in effect for a long time. There are reasons derived from things like double jeopardy analysis, merger analysis, that lead toward the definition that we have given it in whether it's Lehman or the other cases. And at this point, if you're going to start talking about policy, shouldn't that be addressed to the legislature?
No, the legislature has answered this because it uses the phrase legally defined, and legally
Which we have made
defined-
clear for many years how we interpret that, and they haven't tried to change it.
Well, it is not, legally defined means what is the actual law of the case that's being given to the jury, and that is contained
I know that's what
in
you
the jury.
want it to be, but we've not said that. We've said
Well,
something entirely different.
I would respectfully disagree, Your Honor. What the court has said is that you don't go on what the evidence at trial is. So in other words, if the court in this case gave the full definition of trafficking and trial counsel argued, Your Honor, all the evidence that was offered was based on possession plus intent, therefore you should give the lesser included offense, I would agree that that is a losing argument. This case is different because the law that was given to the jury required possession plus intent. So this really is a statutory interpretation question of what does legally defined mean. And our position is that the jury instructions...
And I guess what I'm suggesting to you is I understand how you're interpreting that, but that is not, we would be overruling cases in order to agree with you on that.
I respectfully disagree. I don't think you would overrule any cases.
Has
How
this
would we
narrow
not
issue
be-
been raised in the past?
Not to my knowledge, not on the issue of jury instructions.
Well, it's pretty clear that we haven't limited it to statutory, and that we have said that the indictment can. That's good all, correct?
Yeah. May I respond, Your Honor?
Go ahead.
Yes. I was going to elaborate, but I'll leave it there with the red light on.
Well done.
Was that the equivalent of the mic drop?
All right, thank you, counsel. And as is our usual practice, we'll be taking this matter under advisement and issue a written decision in due course. And with that, we're on recess on this matter. I guess we're on recess for the day, technically.
All right. All persons having anything further to do before this is the Supreme Judicial Court, sitting at the law court, may hence depart and give their attendance here at the call of the Chief Justice, as this court now stands adjourned. God save the state of Maine and this honorable court.
Good morning. You can be seated. I think this is the largest number of people I have ever seen in this room. Good morning. We are here for the prize argument. The name of the case is Parker versus ArtSpot. I'd like to welcome all of the guests who are here in the room. Can't possibly name you all, and so I'm not going to pretend. I will specifically recognize, of course, President and Dean Softly. I got both names, right? Both titles. And Judge Wolf, I see, is here. Faculty members, I recognize a few. I know we have the members of the legal writing team here. Professors Ari, Wolf, Niederi. Professor Chapman is here, and I know there's a whole lot of other staff members, and it looks like a lot of students as well here, and other esteemed guests. Welcome. This is an event we do every year. And I think all of us look forward to it tremendously, especially because we don't have to actually decide it. That's always a lovely thing. With that, I will begin with the way I usually do, by calling the case, asking counsel to identify themselves by saying your names for the record. For the appellant.
Good morning. My name is Gus Forseth, and with me is Mackenzie Blackwell, and together we represent the appellant, Nathan Parker.
Thank you.
Good morning, Your Honor. My name is Adam Fortier-Brown, and I'm joined by Patrick Miskovsky. Together we represent the appellee, ArtSpot, LLC.
Thank you. Well, counsel, Attorney Forseth, if you're ready to proceed, we'd be happy to hear your argument.
May it please the court. Good morning, Chief Justice, Your Honors. The Americans with Disabilities Act provides a broad mandate with a sweeping purpose of eliminating discrimination and integrating disabled Americans into the economic and social mainstreams of American life. In 2024, more than 300 million Americans used the internet. Moreover, the ADA affords more than 40 million Americans the right to the full and equal enjoyment of the services of public accommodations. As a remedial civil rights statute, the ADA should broadly apply with equal force to non-physical places. Your Honors, this court should adopt a rule that holds that websites are public accommodations under Title III of the Americans with Disabilities Act when they affect commerce and fall under one of the 12 enumerated categories of Section 121.81, subsection 7. The following 3 reasons support our rule. First, the plain text of Title III does not limit its applicability to only physical places. Second, classic tools of construction favor a liberal reading that avoids absurd results. And finally, this rule is consistent with this court's precedent and the growing trend among district courts. I now welcome your questions. Turning to my first point.
Well, the green light's on. So this is a website that is not used to order anything off the, it's not really an extension of the physical location. Why isn't it like an ad? Why isn't it like a flyer that you put on people's doors?
Your Honor, this website provides a service to the public.
So does a flyer.
So does any ad.
Correct, Your Honors. I would point you to page 40 of the Joint Appendix, wherein the description of this website is more than just a flyer or an advertisement. This website provides information about classes that ArtSpot provides.
So a flyer may do that too. It could say we are offering classes. This is where we're located. This is what our hours are. Please come and check us out. Is that flyer a place of public accommodation?
Your Honor, this website, unlike a flyer, updates regularly. It updates and provides information about classes. It is the only spot that someone, like my client Nathan Parker, would be able to figure out if there's a class that is offered that he would like to attend.
He could call them, find out.
And
he could go there.
And Your Honor, that same information is contained within the website. The only way to sign up for those classes is to call the website or
But why is, I'm still not sure I understand why that website is different from the flyer.
This website allows individuals like Nathan Parker to check for class availability.
I understand it allows that. My question is, if a flyer gives you the same information, well, let me back up. Is that flyer also a place of public accommodation?
Your Honor, Congress enacted this act, the Americans with Disability Act, to eliminate discrimination.
So if
I
the flyer
understand
had
that.
the exact same information that is on this website, would it also need to include that information in Braille?
Your Honor, arguably it would. It would, because this is a broad remedial civil rights statute that in 1990, when Congress passed it.
But the statute doesn't say anything about websites.
As you know, you have a statute here that defines public accommodations, lists a bunch of kind of brick and mortar places, all physical entities, nothing that exists in cyberspace or nothing that's made up of bits and bytes and things that really don't exist except made up of electrons. And that in 2008, when we were well into the cyber age, Congress tinkered with the ADA again, had a perfect opportunity there, and probably encouraged by the Department of Justice, and didn't answer this important question. Doesn't that lead us to the conclusion that Congress didn't intend to include anything except these brick and mortar public accommodations?
Your Honor, the examples within the statute are just that. They're examples. They are not, it's not, public accommodation is not limited to those 50 examples. And I would argue that the through line through the examples within the statute are not solely defined by their physical characteristics. They are the common thread between them all is that they are places of commonality.
But my question, I get that, but my question is, they are all physical locations. And Congress, what we're trying to do here is to discern the legislative branch's intent, what they had in mind. And we look at it and say, okay, you did tinker with it in 2008. And my question to you is, can we draw anything from that? Can we make any inference or conclusion from that?
In 2008, when Congress amended it, they were looking at the definition of disability. They were not concerned with a public accommodation.
They could have been.
Your Honor, prior to this, courts were applying this text broadly. The First Circuit, when interpreting this same statute, noted that the statute is not limited to only physical places. They looked to
Counsel, you would agree that the accommodation has to fit within one of the enumerated categories?
Yes, Your Honor.
Which one does it fit in?
Subsection F, Your Honor.
And why is that?
ArtSpot's website is a other service establishment. Going back to Chief Justice's point about the service.
But each of those items, every single one of them, is a physical place. Even the travel service. I mean, you go to a travel agency and they provide a service. You go to an insurance agency and they provide a service. I guess this circles back to what the meaning of a service establishment is, right?
Correct, Your Honor. And the First Circuit, when looking at this, they noted that travel services are not, they're not a public accommodation that is solely physical in nature. In 1994, just 4 years after the passage of this act, the First Circuit looked to the language, looked to travel services, and noted that that is a public accommodation that is predominantly carried out by web or over the telephone. And as such, they read the statute broadly and noted that because of the inclusion of travel services, this is a broad statute and it can apply to more than just physical places.
Can I ask you this? Are you arguing that the website from ArtSpot standing alone is itself a place of public accommodation? Or are you arguing that the stores are places of public accommodation and that the website is one of the services that they offer?
The former, Your Honor. That
the website standing alone is a place of
What
public.
if the website did not describe the products that ArtSpot sells at its physical location, simply had contact information? Would it still be deemed to be affecting commerce for purposes of the statute?
Yes, Your Honor. I would argue it would. Under the definition of commerce that the ADA provides, it simply states that commerce means, among other things, communication among the several states. And that's what ArtSpot's website is doing here. It is communicating the services that they provide, like the classes, in addition to the products they offer, as well as their location, their hours.
But
their
is there a
telephone.
difference between communicating the services on the website and discriminating in the offering of the services?
Your Honor, the difference would be that ArtSpot's website is not, because it is not accessible to my client, Nathan Parker, he is unable to access the same services in the same manner that someone with...
I'd like to take you to, in your brief, footnote 1, you cite DOJ guidance. And it refers to goods, services, privileges, and it says it includes those offered on the web. Setting aside what offered means, what weight should we give to agency guidance?
Your Honor, we should give Skidmore deference to agency guidance on that issue. And all that means is that if that has the power to persuade you here, then you should feel inclined to follow that if you so wish.
And building on that, if we were to accept your premise and go your way, please dictate what our holding would be. What should we say out loud?
Your Honor, that websites can be public accommodations under Title III when they affect commerce and fall within one of the 12 enumerated categories of Section 121.81.
When would
subsection
a
7.
website that Art Shop have not be subject to the ADA? What would it have to be limited to?
It would have, the two limiting factors in my rule are the commerce piece and the 12 enumerated categories. If the website doesn't fall within one of the 12 enumerated...
Well, Art Shop is engaged in commerce, correct?
Correct, Your Honor.
So if Art Shop has a website that says anything, is it subject to the ADA?
If it is providing a service to the public, which we can read broadly...
Which Art Shop sells stuff in its physical location. So are you saying any website that Art Shop has to be accessible?
Yes, Your Honor, I am.
I mean, is it sufficient if it's just basically a picture of the store? Come one, come all, picture of the store. Is that discriminating in a place of public accommodation because of that website?
Your Honor, I do think that is more of an attenuated example here, but in that...
So how do we distinguish which websites are and which websites aren't places of public accommodation?
Following district court's guidance that have interpreted this statute, they have looked to the services offered and looked at them as a basket of services. Courts across this country have held that if they provide information such as telephone number, website, or their physical address, products offered, that is a basket of services that is to be subject to
Wouldn't a
Title III.
clearer line be if you could purchase services, for example, through the website, or order services or goods through the website? Wouldn't that be a much clearer line, which would then account for things like Netflix or Amazon, where you are doing it through a website?
While the ability to purchase services is undoubtedly a clear line, that same line or line of reasoning can be applied here. While you can't purchase something through...
But what service are you accessing through the website here?
What's of value here to my client, Nathan Parker, is that he is able to go onto the website and look up the different products offered, the different types of...
So he's able to glean information. And if Congress hasn't stepped in and solved this problem by giving us some clearer guidance, there are technological changes that are taking place. I have this thing that I pull out, my iPhone, and it's got AI on it. Why can't he utilize that as a way of dealing with the specific issues that he has? It doesn't require us to then step in and impose some arbitrary fix.
Your Honor, I do think that point is well taken because the statute provides for the undue burden aspect, or it provides for a safeguard regarding the undue burden. That is an avenue where ArtSpot may be able to comply with the requirements of Title III while also adhering to the statute's broad purpose of eliminating discrimination. Finally, if we were to read this statute narrowly, it would be absurd to apply it in such a way where it only applies to physical places. Today, so much of American life happens online. And to cabin a statute to only apply to physical places would ignore broad.
Finish your sentence.
It would ignore broad companies and important companies such as Amazon and Facebook. Thank you, Your Honors.
Thank you. Attorney Fortier-Brown. Yes.
Good morning, Chief Justice, Your Honors. May it please the court. This case is about interpreting the ADA as Congress wrote it, not rewriting it to cover what it does not. Title III applies to places of public accommodation, a term that refers to physical locations and not standalone websites. Courts that have properly interpreted this language apply a physical nexus test, ensuring that Title III covers websites only when they function as an extension of a business's brick-and-mortar operations. To the extent that the statute covers websites, it is when these websites serve as proxies for such physical locations. ArtSpot's website, however, functions as a proxy for a flyer or a billboard or another advertisement, not its storefront, which is a place of public accommodation, because its website does not allow visitors to interact with it in any meaningful way. I welcome any questions you may have, Your Honors.
Is there any question that the physical stores that ArtSpot has, they have 3 stores, correct?
Yes, Your Honor.
Is there any question that those stores are places of public accommodation?
No, Your Honor. Those are undoubtedly places of public accommodation.
Okay. And is the website not a service offered by those stores?
Not under the ADA's definition of a service, Your Honor. The ADA, it doesn't define service in and of itself, but it does mention it in subsection F as an other service establishment. And under the canon of e jusdem generis, it must be interpreted in the relation to the things that preceded it. And
But it's not, you're looking at the definitions of places of public accommodation. I'm looking at 12182 sub A, where it says discrimination is prohibited in the full and equal enjoyment of the services of any place of public accommodation. Why isn't the website a service of a place of public accommodation?
in the context of the law, Your Honor, a service is meant as either a good or service. So it's something that you would purchase from a company that is not a good. So someone repairing your car, giving you a haircut, things like that. And ArtSpot's website does not do that. It's more akin to a flyer or a billboard. There's no commerce being conducted through its website.
So then is Amazon website not a place of public accommodation, or Netflix?
Those websites are distinguishable from ArtSpot's website, Your Honor. A website is not always, not all websites are created equal.
What
so to
is
speak.
the distinguishing factor?
Well, you have to purchase items through Amazon. You have at least the ability to purchase items through Amazon.
So is that the dividing line, since you can't actually purchase any goods or services through the website? You're saying until you can purchase goods or services, it's not offering them?
Being able
It's
to
not subject to Title III?
Being able to purchase an item through a website would certainly create a physical nexus, and if this court were to be of the opinion that a website could be a place of public accommodation, then certainly purchasing an item would be the equivalent of a physical storefront.
Well,
What about our decision in Palazzi? Does that support your case, or does it not? Our decision in the Palazzi case?
It would support our argument here, Your Honor, because in that case, a travel service or an insurance plan that was purchased was covered explicitly under Title III of the ADA, and it was an extension of that storefront. It was covering, in Palazzi, what the court decided was not whether a standalone website constituted a place of public accommodation, but rather whether if a physical premise of a business constitutes a place of public accommodation, and the goods and services sold from those premises are subject to equal access under the ADA.
Didn't we say that the statute was meant to guarantee more than mere physical access?
Certainly, Your Honor, but again, there's a prerequisite to be able to get that, which is that the place, you have to be able to purchase some sort of good for it. And here, ArtSpot's website does not offer any ability to purchase anything.
Well, it allows you to get to
These weren't going through a website. They were probably acting by telephone or through the mail.
Certainly.
And the issue was whether the company could deny them that service based on their disability. Why isn't that directly on point here?
Because ArtSpot's website does not allow you to purchase anything even over the phone. So no one is being denied equal access. Just
Well,
no
if they
one...
don't know where ArtSpot is, or they don't know what the phone number is, if they can't contact them, doesn't that impede the commerce, and doesn't that impede their ability to access its services?
It may, Your Honor, but there were certainly commensurate opportunity, or certainly things that existed at the time the ADA was passed, like phone books, for example, before the internet was widespread, that included that information. And Congress did not extend the definition of a place of public accommodation to that, which implies that Congress did not want, or did not need, or desire to cover that sort of thing under the ADA.
You started your argument by having a textual argument, saying that it was clear on the text. Is that correct?
Yes, Your Honor.
And you're focusing on the word place. Is that correct?
The word place and the full term place of public accommodation, Your Honor, yes.
So the inference is that a place is a physical location, correct?
Correct, Your Honor.
Don't we call them web sites? Isn't a site also something that before the internet we thought was a physical location?
It has an address?
Yes, Your Honor. That's certainly parlance now and common phrasing now, Your Honor, but we must, when confronted with interpreting the law, we need to look at what did the crafters of the law mean when they put it in the context of the statute.
And also, when they reviewed it down the road, is the term public accommodation, is that ambiguous?
I would not say so.
Reasonable people disagree on what that means in the context of this statute? For instance, your opponent, who obviously is a reasonable person, as you are, you disagree? Isn't that the very definition of ambiguity?
I agree with you, Your Honor. And a place of public accommodation has a long-standing common law definition, which is a business with a heightened duty due to the public nature of its business.
I've got that. I wanted to, that's a predicate to my next question, which is, sorry about suffering from the plague up here.
I'll keep my distance.
All right. I'll try not to project. The Department of Justice, which is the agency assigned to administer this particular law, has come out and said that the ADA's requirements apply to all goods, services, privileges, et cetera, including those offered on the web. And in fact, when the hearings before the House subcommittee took place, they said, and I quote, "It is the opinion of the DOJ currently that the accessibility requirements of ADA already apply to private internet websites and services." So Congress is hearing this, saying, oh, okay, well, if it already addresses it, we don't really need to amend the statute. What are we to make of that? The fact that Congress heard it's already covered and they didn't make any changes to the statute. Does that help us or hinder us in trying to discern the legislative intent here?
I think when looking at the legislative intent, Your Honor, it's important to recognize that the DOJ guidance is merely an opinion and it's not a binding rule, Your Honor. It's certainly within the DOJ's ability to craft a rule to cover websites, but they have also said, Your Honor, that doing so is incredibly difficult, incredibly technical, and they're trying to avoid to do so because of the unforeseen consequences of improperly writing one. So while I think to that point, Your Honor, while Congress, in the context of that information that DOJ was providing to Congress, Congress necessarily knew that this was a complicated area to regulate, it was ambiguous, it was unclear, and perhaps Congress should do something about it.
Do we take anything from the fact that Congress didn't do something about it?
Certainly, and I think when taken in the context of Congress's broader regulation of the internet, it's more telling. For example, in 1996, 6 years after the ADA was passed, Congress passed the Telecommunications Act, which created a minimum government regulation for the internet as a public policy standard. And that's been upheld across administrations. Even with how polarized things have been, there's been remarkable consistency that Congress has not wanted to overly regulate the internet as a matter of policy. And here, when looking at the context of all of this, Your Honor, it's clear that Congress had the ability to extend the ADA at any point, especially in 2008, when it was amending it to your prior point, Your Honor, to extend the ADA to websites, and it chose not to. And when reading the law as written, it shows that a place of public accommodation, it defines it through terms of 12 categories. And
Well, just to get back to my, I'll ask one more time and leave it alone, but
Okay.
they heard from DOJ that it's already covered. Now, they could have done one of two things. They could have said, DOJ, we're not going to pay attention to what you're saying. We're going to go ahead and make sure it's covered. Or they could have said, okay, if it's already covered, we don't need to mess with it. Why do we assume that Congress did not intend, in your view, to include websites in the protections here?
When looking at the DOJ guidance that had been issued, it also defines a place of public accommodation. And it uses terms like facility, which in turn is defined as, it defines in its own policy guidance as all or any portion of buildings, structures, sites, complexes, equipment, it goes on, including where the building, property, structure, or equipment is located.
Which is why there's no question that the stores themselves are places of public accommodation.
Yes, Your Honor.
Still not following why their website is not a service or privilege or advantage that that store, which is conceitedly a place of public accommodation, is offering.
I mean, when customers go into a physical location, they get to browse the merchandise. And your website, your client's website, offers the opportunity for sighted people to browse the merchandise, but it denies that opportunity to visually impaired people, apparently. Why isn't that a violation?
It's my understanding, Your Honor, from the facts presented that ArtSpot's website does not provide the opportunity to browse goods or services that it provides. I'd point your attention to page 29 of the Statement of Material Facts. It's point number 7 on that page, Your Honor, and it is referring to an aspect of the deposition, if I can speak here, where the owner of the website, the owner of ArtSpot, makes clear that he posts a picture of a flyer that he hangs in his store and a picture of a flyer about the classes that he has, but there's no current ability to browse goods or services. There's no current outside of a flyer that you could find in a newspaper.
Well, paragraph 7 indicates the website provides information about ArtSpot's company history, skipping down, and the ability to browse many of the products and services available at ArtSpot's physical stores.
Yes, it does, Your Honor. And when looking at the deposition, which I believe is on page 35, or the point that it's referencing, that point is clarified. I think that point...
So is there a dispute of material fact then that would prevent this from being decided on summary judgment if it's unclear just what is really offered on that website?
I think that point, Your Honor, makes clear that there is a list of limited access to goods and services that it provides in its store that are listed on its website. But I think what's important to recognize, Your Honor, is that it is provided through an image of a flyer that it has in its store, or an image of a flyer that it has advertising the service.
But it's now being able to distribute to the whole world to see what services, i.e. classes, what goods, i.e. what kind of clay they offer. And even though you can't purchase it there, why is that not, again, information about the goods and services that they offer by a place of public accommodation?
Sure, Your Honor. And I think the best analogy for this is thinking of a catalog, a mail-in catalog, where a store provides a list of sales and goods and services, and you take it in the mail and you can cut it out and you send it back in the mail. Those existed. It's disputed. I mean, it can
They
go.
still do.
They still do. In
They
last
come in
year,
my
this court-
mailbox anyway.
We use them all the time, actually. But this court may take notice that last year, it added, just mail-in catalogs added $125 billion to the U.S. economy, and there were 90 million purchases across the United States through that. So it's still a widely used piece of commerce, and it was widely used back in 1990 when the ADA was passed. Congress knew it existed. It had existed for hundreds of years, Your Honor, and they chose not to extend the ADA to that sort of commerce. They used the term public accommodation, which is, yes, broad sweeping, but it is also necessarily constrained to not include all aspects of the U.S. economy. They defined it through 12 different terms and 50 different examples, Your Honor, of what kind of businesses, what kind of services that the Congress wanted to regulate through the ADA, and none of them align with a website. None of them align with a non-physical location or a catalog or an advertisement. And in deciding this case, Your Honors, if this argument is not convincing, also consider the consequences of holding that any non-physical location,
You can finish your sentence.
that any non-physical location or any non-physical service or advertisement, it would be covered by the ADA. That would have tremendous consequences, Your Honor.
Thank you.
Thank you.
Attorney Forsyth, I understand you reserved 2 minutes for rebuttal. Why isn't your stronger argument that the store itself is clearly and conceitedly a place of public accommodation, and that the website is essentially a service privilege advantage that it offers, and that that's why it needs, I mean, you're arguing that the website itself is a place of public accommodation.
Your Honor, under the nexus test, which you are referring to, ArtSpot's website would undoubtedly be a subject to Title III's requirements. However, although the lower court did not find that such a nexus existed here, their nexus test was too narrow and did not align with the broad purpose of this act. Your Honors, we would ask this court to apply a nexus test that states that a nexus exists when a website is integrated with the store's physical location and facilitates the use of the store's services. And Chief Justice, your point earlier, or question regarding the requirement to purchase, highlights the issues with such a narrow nexus test. If it were true that someone had to go or had the ability to purchase something through a website, that renders the nexus unnecessary, because you could stay at home and order goods and services from that place without ever going to the store itself. The nexus exists so that, and here specifically, so that my client can go onto the website, see if ArtSpot's offering a class he likes or restocked his favorite type of clay, and then is able to order an Uber and go down to the store. That's the nexus test that we are asking this court to apply. A narrower nexus test does not.
So this is really an alternative, because when I asked you in your initial argument, you said you were arguing that the website itself, independently of any store, was a place of public accommodation.
Correct, Your Honor. And in the alternative, we would ask this court to find that a nexus test exists.
Okay.
I see that my time is up. Thank you, Your Honors.
Thank you. At this point in the proceedings, I ordinarily say, thank you for your arguments, and as is our usual practice, we'll take the matter under advisement and issue a written decision. But we're not. Instead, you are going to take a deep breath, and everybody else is going to give them a round of applause. If nothing else, they had to be nervous performing in front of quite so many people. I'm going to invite my colleagues to see if they have anything they want to say to you. I don't know if anybody does.
Just very well done, both sides. The briefs were excellent. The arguments were very clear and responsive. Thank you.
Well, while these arguments were going on, I know that I was thinking, oh, I'm so glad I don't have to do this anymore. especially in front of such a huge crowd with my boss looking at me. And I think you both did really good jobs. And I thought the briefs were very good. And, you know, it's the briefs that matter the most when you go off into the real world.
Absolutely terrific. I mean, if this is the quality that the law school is producing, you're being well served. And as to one else here today, congratulations on choosing such a great institution. As with any institution, your education depends on the effort that you put into it. And there's a lot to be here, so take it all in, and maybe someday you'll be sitting in this position or the equivalent of it. So well done. Congratulations.
Congratulations. I just want to mention that the questioning and the atmospherics that you experienced during this argument was pretty realistic. We have a couple of law court judicial clerks in the courtroom who sit through our arguments, and I think they would confirm that this was real. So anyway, and everybody held their own. The briefs were very solid, covered the issues, made backup arguments when those were appropriate. And anyway, so as the saying goes, I think all of us are hoping to see you in court someday, to coin a phrase.
Well, I'll make it a more pointed phrase. Based upon this presentation, I look forward to seeing you in this court. And my congratulations to Dean Softly and the members of the faculty for doing a wonderful job with these folks. I'm looking forward to seeing all you coming back and practicing in this state.
My question is, how did it feel?
Feels better now, doesn't
Better
it?
that it's over.
I had fun with it. I liked it. All the preparing was really good. Questions were hard, but I expected that.
Were there some unexpected questions?
Yep. Yes, Your Honor. Yes, Your Honor. I think Justice Mead saw how unexpected that DOJ line of questioning was for me. So.
But well done. That's, you're an infielder and you have to take the shots wherever they come from, and they come fast. But you caught it and made the play.
And do you have questions for us?
We won't tell you who we'd vote for.
No.
Well, then we'll say
We're taking a vacation from having to decide.
We know it in your heart.
Everybody wins.
Yeah, we all win. I think we both. I can speak for both of us in saying we really appreciate the opportunity to do this and be in front of you guys, and for this to feel so real. I think that's so central to our education, and I know I would certainly benefit from any feedback or critical feedback that you guys had about how we presented or demeanor or things like that.
You did a lovely job. Both of you did, really. And so we just wanted to give you this opportunity for seeing if you had any questions for us.
I guess I do have a really maybe niche question, but I'm wondering, are there certain things you look for in oral lists that outside of the oral presentation, but say lack of notes or just a one-page thing of notes? Are there any intangible things that you look to?
I think that for most of us, and maybe I'll let everybody else chime in, oral argument is really, it's really not for you to shine, it's for us to get questions answered. And so from that perspective, you should welcome the questions, and I would suggest get right to it because you have such a limited amount of time. And listen to the questions, and believe me, you can't always divine where we're going or what we really think, I promise you. But the questions are really an opportunity to help your argument shine. And so you may end up presenting it somewhat differently than you were thinking of it. But take it, and it's like, oh, okay, welcome the questions. So I think from the perspective of this court, and neither of you reserved a lot of time, which is, I think, good. We don't actually, you only get 15 minutes. And so if you give us a speech for 3 minutes that simply repeats what you said in your brief, you've kind of wasted some of your time. So you didn't, and that's good. I think having some protected time at the beginning is always fine, because you can always cede it back, which you did.
Your tone was great. Occasionally people feel like they're being flogged by us, and they take it personally and they get tested. It actually contentious, and that things start on a downhill slide when it happens. You have to realize that it's not a personal attack. It's not even an attack on the argument. It's probing, and you did a fine job of keeping things upbeat. And I know I see Dean softly smiling occasionally. We've had dust-ups in the courtroom with people making oral argument, and it is not effective. So.
Anything else anybody wants to ask or? Well done. Thank you. Well done.
Thank you.
And with that, the court actually is in recess.
All right.